Appeal number 63, DNR Global Selections versus Bodega, Olegario, Falcon, Pineiro.
May it please the court, my name is Robert Zara, and I represent the appellant, DNR Olegario. This case comes...
Mr. Zara, would you like to reserve any rebuttal time, sir?
I'm sorry, Judge DeFiore. Yes, I would like to reserve 2 minutes for rebuttal.
You may.
Thank you for reminding me. So this case comes before the court after several years of litigation on the issue of personal and subject matter jurisdiction after the Honorable Diamond stated in January 2010 that, May 2010, May 25, 2010, that the defendant has conceded that it contracted to supply wine to New York, and under the contracting anywhere to supply goods or services to New York, that takes care of the first prong of the statute. And then on the second prong of the statute, she used Lupton, the Lupton case, and she basically said, like Lupton, you have here a commission agreement that the origin of which is that contract in Spain to supply goods or services in New York. So by definition, you have met the arising from requirement, which is the requirement that 302A1 requires. The drafters of 302A1, did not say it has to be caused, they just said it has to be arisen, and this court in...
So how does the claim for the commissions arise from the fact that they came and they had their representatives come to New York to basically solicit business?
So, Judge Rivera, basically the affidavit of my client, Ms. Monica Duarte, that starts in the 500s, essentially states, and the same thing for the affidavit of Erica Lash. They both state that they came here to solicit, they came here to assist in promoting their wine. That assistance led to sales, and from that sales, you have the commissions. The respondent has admitted at page 24 of its brief...
So is the argument that your client opened the door for this type of solicitation, made it possible for them to have these meetings and attend the Ritz-Carlton launch and all of that?
Well, it's not... I wouldn't say really that my client opened the door. This was basically a situation where my client was going to come here to New York to promote another winery's, wine, and the defendant got wind of this and called her to come and have a meeting at the winery. And at the winery, back in March 2005, they agreed that, look, if you also can, sell, our wine, if you can find for us specifically a distributor. And the defendant has admitted to this at page 60-62 of the record in the affidavit of Maria Obiña. That was the deal, that basically, you will be entitled to a commission. Now, the thing here is that there are two agreements.
Yes, but isn't the transacting business the fact that they came to New York? Not that you came to New York.
They came with us. They came with us. They came to...
But that's what I'm saying. Is your argument that they came with you because your client opened these doors and made it possible?
Yes. I appreciate that question, Judge Rivera. So there are two things here. There is the order of the appellate division back in 2001 that construes that the transaction of business, the purposeful availment, the transaction of business in terms of looking at the conduct of the agent. And then you have the reality. The reality is that the defendant came here on several occasions, and that is not, that is specifically averred in the affidavit, sworn to in the affidavit of Monica Duarte. It is also in the record in the inquest hearing. They came here for a great match in March 2005. They came here for the kickoff at the Ritz-Carlton. That's the big event that Coburn organizes in January 2006. They may have participated in the event, they did participate at the event in Solera Restaurant, which was one day before the kickoff.
So can you help me out here? They moved for summary judgment.
Yes, Your
You
Honor.
did not cross-move for summary judgment, correct?
We actually cross-moved for jurisdictional discovery, but the Honorable Mendez denied that,
Okay.
except that he dismissed the personal jurisdiction.
But you haven't asserted that you're entitled to judgment as a matter of law.
No, I did not cross my, yes,
Okay.
Your Honor.
All right, so my question is, you repeatedly refer in your brief to the numerous triable issues of fact.
Right.
What are they?
So basically, there are the issues of fact that will, that are open in the event the court determines that the affidavit of Monica Duarte pertaining to their visits in New York are not, enough to confer jurisdiction on the transaction business. And she mentioned several things in her
But
affidavit.
are they disputing the acts that you allege that they did while in New York?
Well, in the deposition, which is at R-767, Judge Stein, they basically admit that Roberto Falcon came to New York and, that was there with my client, DNR's Monica Duarte, and that she did whatever people do at fairs, which is promote and sell.
So beside the legal conclusion of whether that is enough here,
Right.
what are the factual disputes?
Okay, so the factual dispute. So, for example, you have in the record several versions of a draft distribution agreement. So that draft distribution agreement goes back and forth. There's an Article 11 there about the jurisdictional clause, and first, it includes a jurisdictional clause for the ICC chamber in Paris, which was apparently put by, the defendant. They changed the New York jurisdictional clause that, Colbrand had sent to them, Colbrand being here the, importer. So they put, Paris, and then there was a meeting in, in Bordeaux, France, and basically, there is, evidence in the record that they were going to discuss this contract, and then all of a sudden, okay, we see that it goes back to New York, and then it goes to New York Chamber.
So the issues of fact aren't so much about jurisdiction as they are about the merits of your claim,
No,
is that?
no, no.
Okay, I'm misunderstanding
Okay,
you.
So basically, our contention, Your Honor, is that jurisdiction here, under either of the bases established in 302A1, which is the transacting business and the contracting anywhere to supply, and with each case, the claim arising from, that, because that requirement pertains to both bases of jurisdiction, to us, clearly there is jurisdiction.
Mr.
And-
Zara, getting back to your argument on the contract to supply goods, so the defendant is not a resident of New York State, correct? And the cause of action doesn't arise out of the contract to supply the wine?
Right.
Correct?
Well, actually-
So my question to you, sir, is what is the authority you cite to that we can rely on that extends personal jurisdiction under those circumstances?
That's Lupton, Your Honor. The Lupton case, which is a case by the Fourth Department, which is the same case that the Honorable Diamond used in her order, which is at 12930, essentially states that privity of contract is not required.
You're talking about Alan Lupton versus Northeast Plastics or Plumbing, I can't remember yet.
They basically say that privity of contract is not required here. The claim for commission arises, okay, out of defendant's contract in Spain to supply wine in New York. Therefore, that is enough to meet the arising from requirement. And under this court's relaxed arising from requirement in Lychee, we believe that the claim for commissions is not unmoored. This is the word that the court used.
No, I agree with you. I think that the Lupton case was written by my friend Judge Green years ago, and it's a well-written decision, and it does seem to support your point of view, but of course it's an appellate division case, and it's not binding on this court. Here, I think we're looking at Lychee and then comparing Lychee, which is the Lebanese-Canadian Lychee, you're familiar with that case, and to some of our commercial cases like Talbot and the SPCA cases, assuming you're familiar with those. And there seems to be a distinction between Lychee, which is sort of, it's a terrorist correspondent account case. That seems to be a broader standard versus Talbot and SPCA, the defamation cases, and that seems to be a somewhat narrower standard. Where do you fall on that spectrum?
So looking at Talbot, for example, right?
Okay.
You have the Talbot defamation case. So you have the court that essentially says, look, the transaction here, is, which is attendance at the school, is to remove in time 2 years, okay, from the cause of action, which is a defamation. And that means that the link, the rope, will just not hold, it will break. That is too attenuated. The link is just too attenuated. Here, the link is clear. It's super clear on the 302A1, contracting anywhere to supply goods or services, because they themselves admitted that they're entitled to a commission if you provide an importer which will buy the wine. The link could not be clearer. And even on the transactional business, the link also is clear here, because it's clear that their participation at various industry fairs shows here basically drove up, the sales, and that in turn generated the commission. So again, the link is not so attenuated. It's not as strong as the link in the 302A1 contracting anywhere, but it's not as attenuated such that there shouldn't be an arising from, such that the court would find that the arising from requirement is not met in that circumstance.
Thank you, counsel.
Thank you, Your Honor.
Counsel?
Good afternoon, Your Honors.
Good afternoon.
John Gleason, on behalf of the defendant, respondent. The second decision by the Appellate Division, a unanimous decision, should be affirmed. It was plaintiff alone who brought the wine from Spain into New York.
Well, isn't the essence of their claim that they entered an agreement to find a distributor, and they claim co-brand as that distributor, that distributor is only you're only in a relationship with that distributor based on their efforts, and therefore they're entitled to commissions, or plaintiff's entitled to commissions for each of those bottles of wine that's sold through that distributor. And if that's their claim, why isn't that, as we said in Lychee, at a minimum, related, shows relatedness between the transaction and the claim? How is that not at a minimum related?
Because it was the plaintiff alone that made that arrangement. It was an arrangement between co-brand and the plaintiff. Co-brand brought the wine in because plaintiff asked it to.
But on
I'm
behalf
sorry.
of your client, correct?
But that's
It
his claim.
benefited. I don't think it was on behalf. It benefited the winery, but the winery was paid in Spain in euros.
So what would have had to have happened for it to have been related then? You're saying that your client would have had to directly ask co-brand
Or do it herself.
or do it herself?
I-
Okay.
It's
Well,
two
well,
women that run
is
the-
it, aren't they arguing that is exactly what happened?
No. Some wineries, in fact, do that. They directly import their own wine into the United States.
No, but
Here-
didn't your client make an arrangement with co-brand?
No. The
How
arrangement,
did, after the year was up, how did the wine get here? You
There's an
don't
important-
disagree that it has gotten here?
yes, but there's something we're losing sight of. The agreement between DNR and the winery was oral. They came from the same town in Spain.
No, you're
They
not
knew each other.
asking
It's
my
not about the
question.
merits.
I know, but I'm getting to it. I'm sorry, I'm long-winded. I'm too used to being in front of trial courts.
You'll run out of time, though, that way.
I know.
Yeah, I'd like you to just answer how that wine, after the 1 year, how that wine has gotten to New York.
Because the oral agreement was terminated by the winery, and then the winery said to co-brand, if you still want to import our wine, we're willing.
You're saying that the agreement was over, you don't owe them any more commissions, so then you, or your client, not you, obviously, went about the business of entering their own separate agreement with co-brand. So they dispute that, right? So that's on the merits. The question now is about jurisdiction. That may be your argument on the merits, that may be your defense, that's fine and dandy, that's not what we're here for.
But the appellant is saying that those contacts that the winery had with co-brand after the oral agreement was over justified jurisdiction.
You're saying your client came to New York after the one-year period?
Yep.
So you had not paid, or your client had already paid certain commissions
Yes.
before ever coming to New York?
Yes, paid quite a bit of commissions. If you look at the record, it'll show.
Before ever coming
that-
to New York, that is,
Sorry, Your Honor?
before ever coming to New York? Your client didn't come during the first year or before that?
No, if you look at the record, the inquest testimony given by Ms. Duarte, she says, I went to the Great Match alone, I went to Miami alone, I went to Paris alone, I paid for the trips, excuse me, my company paid for the
So
expenses.
Co-Brand was distributing your client's wine before your client ever came to New York for those visits?
Yes.
Before the launch at the Ritz-Carlton?
That I don't know, but Duarte did.
Well, that's one of the trips.
Duarte did make the arrangement between Co-Brand and the winery. There's no doubt about that, and they were paid for the commissions for that time.
Okay, so if you agree to that, let's stay with that for one moment. If you agree to that, and their argument is, that's the point, we found the distributor, they were selling, they were getting the wine, they were ensuring the wine was distributed, and therefore your client was profiting off of that, and they're entitled to commissions for having created that opportunity and getting the distributor.
That would work if there had been an agreement to that effect, but the agreement...
Okay, but that's on the
for-
merits, that's on the merits, we're talking about jurisdiction.
Right. The appellate division said it perfectly. It was plaintiff alone who brought the wine in. Remember, if you look at the record, it shows these contracts are ex works. That means Olegario puts its wine at the back door
How is that relevant, to the jurisdictional?
because the sale was complete in Spain.
But that's comparable to FOB here, and I didn't think that that was the sole basis for our decisions anymore.
I'm sorry, I couldn't hear.
Ex Works in Europe is comparable to FOB, free on board, the same analysis in the States, and I didn't think that that was dispositive anymore, particularly in New York.
I don't mean to argue with you, Your Honor, but I...
No, that's what you do mean to do. That's what you're here for. Don't worry about that. Tell me what you think.
Okay, I didn't mean to be rude.
Yeah.
What it means is that the purchaser, Co-Brand, picks it up at the winery and takes title and possession.
Well, we know that,
Title passes.
but isn't that based on our old mere shipment rule, that the mere shipment wasn't enough? And hasn't that been
I don't know the
abrogated?
answer to that, but-
Hasn't that been abrogated pretty clearly by the statute? Haven't we said that?
Well, it may be, but I think that's irrelevant. What we're dealing here with is what happened in Spain. The wine was presented to Co-Brand in Spain.
Well, I think that's exactly what we used to rule based on the FOB and the mere shipment rule, but we kind of moved beyond that.
The legislature specifically amended the CPLR
I
on that,
didn't
but
mean
let me ask you this.
Sorry.
Let me ask you this. If your client had indeed come to New York during the year,
Ah,
is there personal jurisdiction leading to the subject matter jurisdiction?
that would be different. If Co-Brand in the year after the DNR agreement had been terminated, if Co-Brand wanted to sue the winery...
No, that was
they
not my
would do
question.
here.
Well, yes, because you've got an agreement, that's
Yeah.
not the question. No. During the year, during that 1 year that you concede there is an agreement with the plaintiff, if your client's representatives had come to New York, does that then satisfy the requirement?
It would depend. It would depend if the coming to New York was purposeful, meaningful, with the intention to do business.
Well, let's assume that is the case.
Well, then, I think that's a hypothetical, but a hypothetical.
Yeah, it's a hypothetical I'm
probably, yeah.
giving you, so I want to know what your answer is to that.
Hypothetically, probably, yes.
And
But
then
I don't think
why
that-
is there not a question of fact about that?
I don't think those facts came to pass in this case.
Well, you don't, I know you don't, but the plaintiff says they did. Why?
Not in the year of that
I
agreement
think that's-
between DNR and the winery.
There's a finding by the appellate division, right, that your client did transact business in New York, right? And as to the first prong of 302A1, at least as reading your papers, I concluded
Right.
you were not disputing transaction of business. This was just about nexus. Is that wrong?
Right, we don't disagree with what the appellate division said, but the appellate division added in the next clause, there was no nexus between that activity and the claim by DNR for
So we're
commissions.
not really arguing about transaction of business, just about nexus, right?
Right.
Okay.
So then, to
But
follow
I
up on
took your
that,
argument is that when you're transacting business is not when their claim arises.
Right,
Is that your point?
right, exactly.
That those events that lead to the transacting business or your client's representatives coming to New York
Right.
falls outside the 1 year period.
Right, the
This is
winery
your
took no
position?
purposeful activity in New York.
Would I be correct in saying that there's three events here? They've got Falcon and Mosterio attend a great match event in Manhattan, May 19, 2005. That's one. Second is they attended, Falcone attended the co-brand dinner on January 2006, and then Falcone attended the co-brand kickoff event the next day at the Manhattan Ritz-Carlton. Those three events, is the question before us whether or not they constitute an articulable nexus between defendants' promotional activities in New York and plaintiff's claim for the commissions?
Yes, and if I may add.
Sure, go ahead.
In 2006, the agreement with the DNR was over.
Okay, thanks.
Yes, in March 2006, because he claims the agreement is from March 2005.
Right.
So coming into New York occurs, those events occurred before March 2006.
Okay. I agree, though, with Justice Fahey that there's no nexus between those events and the claim for commissions.
Counsel,
That's exactly, I'm sorry.
are you making solely a CPLR 302 claim, or are you also raising a constitutional due process claim?
Yes. We raised
Yes, to
that.
which one?
Well, I mean, our U.S. Supreme Court has said that there has got to be some significant contact with the United States in order for a court within the United States to exercise jurisdiction over a foreign entity.
And understood. Have you raised that claim here?
Yes, it's in our brief.
And it was raised in the appellate division also?
I believe so. I don't think I made it a major point, but I put it in there.
Thank you, counsel.
Thank you.
Mr. Zara?
A few things, Your Honor. The meetings here in New York, the great match on or about May 19, 2005.
Mr. Zara, I can't hear you. Just pull that mic down a little bit. Thank you. Thank you, sir.
Thank you, Judge Fahey. The meetings that we're talking about here, which is the great match on or about May 19, 2005, that starts everything, because that's the meeting where appellants, Ms. Duarte meets Constance Savage of Colbrand. That's where Ms. Savage takes a few bottles, they do testings, and pursuant to those testings, there are emails in the record that say, your wine has risen to the top of the list, subsequently became one of the world's fourth best wine according to the Wall Street Journal, and that's also in the record. We want to be your exclusive distributor. And so there is a letter that's also in the record, Your Honor, that basically appoints, a letter by Olegario that appoints, a letter by Olegario that appoints Colbrand as their distributor in the United States. Pursuant to the Federal Alcohol Act, they are granted the right of being the primary source of this product, Albarino, for the entire United States. Then you also have the meeting on or about January 9, 2010 at the Solero restaurant. There was a kickoff dinner where basically Colbrand invites all their distributors to basically a kickoff dinner. And then you also have, on or about the next day, you have the Ritz-Carlton kickoff. Those meetings, okay, happened before the defendant began shipping its wine. What had been shipped before were just samples. They were invoiced at like €1, €2. Those were just samples. The business started in earnest after, the kickoff, because that's where the distributors came, liked the wine, were introduced to it, and the orders started to flow. And how? You have 133,000 bottles or so, 720,000 euros. So this constitutional argument that, yes, you could theoretically have a constitutional argument because 302A1 does not exhaust the full panoply of the due process clause. So yes, you could have a situation where,
Well, did he raise it below?
Yes, they did, Your Honor, but the point is they knowingly avail themselves of the benefits of doing business in New York. They shipped, hundreds of thousands of dollars worth of this. They dealt directly. This argument that because it's X works, there is a case, Cleopatra, that clearly says, the FOB Milan case, look, the drafters of the 1979 legislative amendment to 302A1 never intended, that the rule was going to be if you ship. That's why they say supply. okay? And so for, that rule was that amendment was basically designed to protect people here to basically buy from overseas, so they would be able to sue them here. So the idea that because it's ex works, we didn't do it, but the main thing, Your Honor, is that you have 17 invoices from the Bodega, Olegario, to Co-Branch. You have a letter appointing them as the primary, exclusive, primary source of wine for Albarino. And so the idea that somehow they didn't do business with them, that it's, the defendant, that is the plaintiff who brought the wine here, there is no support for it in the record, Your Honor. There's absolutely not.
Thank you, counsel.
Thank you, Your Honor. Thank you very much, the court.
You're welcome.
Thank you, Your Honor.
You're welcome.